And you cannot have any conspiracy theories with treason. Treason requires an overt act with two people. And that means that if you conspire, if you promote it, if you try to assemble it, if you try to enlist it, unless you're the person physically carrying the gun, there's no treason. Matter of fact, the doctrine of being an accessory, being treated as a principal, we often refer that into the law as the spoke and wheel theory, that if you're connected to the spokes in any place, you're connected to the wheel. That means that all accessories are principals, specifically not applied to treason. Everyone has to act as an individual. Now, the reason why I thought that was curious is that you think, well, what did the indictment say about those 41 men? Who were the two witnesses of the same overt act for each of these people? And the most bizarre thing I found, as a matter of fact, I looked for transcripts, and then people say, well, I want to make a footnote. Would they have known about this law, right? Maybe I'm just being picky because I'm a lawyer and I get paid to be picky, all right? But you know, in all that correspondence that they attached to the front end of the stuff that they put into the Missouri legislature, if you go through and look at the correspondence, I find it when they talk about the Aaron Burr case. Clark is talking to Boggs, is talking to King, that they all know that the Burr case is the law of the land. And now, where they understood all of it, but clearly they were aware this was the law. And why do I think they know that also? Because when I look at the indictments themselves, there's blanks. Now, you can't see that very well, can you? So I can say it says whatever I want. But I will tell you what it really says. These are all allegations of acts. The dates are all left blank because they don't have any dates to fill in. Throughout it, there is no evidence of when the acts that they were going to claim were treasonous occurred with whom. Kind of a problem. You kind of think if I was them, I would have filled something in before putting that in the record. But there it sits, somewhat of indictment of this charge available. Well, Joseph was desperately worried, desperately wanting to get the saints, to get his trial moved. And so we know very early on in his petition to the legislature, he noted that we believe that the state of excitement exists in most of the upper counties and such that a jury would be improperly influenced by it, saying, move it to someplace else. At the end of this, when they all get indicted, their lawyers again ask, please change the venue so we can get tried with some legitimacy. But they had a problem, because what the law required was that to get a change of venue, you had to not only make a plea for it, but you have to set out in the last paragraph, the truth of the allegations be supported by an affidavit of any credible, disinterested person. What are you going to do? Well, what you're going to do is you're going to look to Markham, because he solved it for us. Because one thing we know is that there was a new act enacted. It was enacted on March 21st, 1839, in that very session of the legislature. And what did it do? It removed the requirement of using a disinterested person and said it could be, quote, verified by the affidavit of the defendant. And do we think the lawyers understood that? Well, we know that Markham rode a hard horse, they tell us, rode through streams and arrived among us in the afternoon and spent the evening in our company. Brother Markham brought us a written copy of a statute which had been passed by the legislature giving us the privilege of a change of venue on our own affidavit. Well, do you think that was going to work? Do you think they would have good cause? Was it well supported? The judge denies it. But then the rest of the story, because who was the judge? And that's where it gets curious. Because when you look at these front matter of these correspondence, right, that they've attached to the legislature, you start realizing that this guy named Thomas Birch is a good lawyer and entering into this matter with his whole energy. Who is this Thomas Birch? He's the prosecuting attorney. You then further look on where they've attached all these affidavits that were just not properly introduced at the hearing. You introduced all these affidavits were taken by the Honorable Thomas C. Birch, the circuit attorney in the judicial circuit. He was the prosecuting attorney at the Halston King hearing. He is now the judge at Gallatin. Between November and April, he had been made judge. And not only just any judge, he was made a judge for Davis County, and he sat as the judge over this entire hearing. Maybe a conflict? Well, even Thomas Birch could not deny when the lawyers tried to make the move with these new affidavits that Hiram's thinking is going to work, and the judge denies it, they say, but Your Honor, doesn't the law say that the same shall be removed where the judge in any wise interested or shall have been counsel in the cause? He had no choice, and he grants the change of venue. And he grants the change of venue in every single one of the indictments involving our 5 boys. And they're ruled, this is one of them, that the reason that the judge of this court has been a counsel in the cause, and they moved the case to Boone County, to Columbia, in the middle of the state. Now, they take several days. Sheriff Morgan is going to take a couple deputies with him. He's going to take some people we know. Bowen, we know he was the former sheriff. We know Brassfield, he's an interesting deputy. He was the guy that wrestled Joseph at one point. Do you remember? They had a little wrestling match because Joseph was just a nice guy and did some entertainment and threw him several times. And now these guys are out, and they first take him up. They take several days to get where they're going. It don't seem like they're moving very fast. The first day they go up because Bowen needs to get something. It's about 100 miles. First day they go 5. And they take them up to Bowen's house to get some horses and supplies. The only thing's weird is it's really not Bowen's house. He is living in Lyman White's house that he took at Adam and Ammon. And Lyman White is one of the prisoners. So he's saying, I just got to stop by my house. I can imagine Lyman going, your house? This is my house. But nonetheless, kind of a little awkward. They get some extra supplies. Then the next day they go 7 miles. Not in a big hurry. They go to Millport. Where do they stop? They stop at Josiah Moran's house, the friendly judge. And by the second and third day, by the end of the third day on April 16th, well, it's raining one day, so of course they got to stop. But they do go, and by the 16th, they go to a point where our reports are that Morgan said, I'm not going any further. I've gotten you out of the way of all the mobsters in the counties. We've now entered into a new county, and this county now, you're free to go. I'm going no further. I'm not going. Well, he used some words that Hiram keeps putting blanks on, so you have to kind of guess, but they start with letters that you know. And so, he's saying things, I'm not going any blank further. You kind of get an idea of what he was saying. And so then there's a curious part of the story. That's this part of the story that Joseph says, we then had this whiskey that we bought, right? And they all drank it, and they all got drunk, and we walked away. Well, of course, Morgan, several months later, he comes back to town, and everyone wants to know. They got it less than a third of the way. That's how that might be. But he gives an explanation. He gives a written explanation, and he doesn't write very, well, it's kind of, you can see his handwriting. It's not Oliver-like, but he does say that the Smith, White, and others made their escape without the common consent or negligence of myself or said guard. Okay? Well, if I was the sheriff, that's what I'd say. And I'd stay with it. Now, what do you think the citizens thought? The citizens of Gallatin? Well, they actually were so mad about this that they filed a petition. Now, in part, the petition says, we don't think the law will reach these guys, these sheriff. And so we're going to take actions in our own hands. We're petitioning for you to fire them. And in part, he says, but on the contrary, he says, wherein many reports are in circulation relative to the escape of the Mormon prisoners from the sheriff of this county, which have created and confirmed the suspicion of this meeting that their escape was not accidental nor unavoidable. But on the contrary, from the facts within our knowledge and all circumstances taken together, we are forced to accept the opinion that they were willfully set at liberty. Now, that could be Exhibit 1. But everyone wants to find the smoking gun in a case. They want to have that silver bullet. What is going to just win the case? Would this win the case? Probably, I gotta be honest. But would I have anything better? Well, we know that Joseph and the 5 of them left off on 2 horses. And they say that they took turns. Now, sweet Joseph said he didn't take the first turn, which I think is so cool. But I wish he would have, because you remember he said by the time that first day he had run so hard that when he took his boots off, his boots were puddled with blood from running so hard. So you wish you'd just say, Joseph, get on the horse. You know, you're the prophet, you know.